application and happy to answer any questions you may have.
Are there any questions for Mr. Phillips? There are no questions.
Oh, I'm disappointed.
I know.
And grateful.
Did you bring me some bread from Rustica? That would be my question. I love the quality of
No, I should have brought
food.
Next time we'll bring a crepe, though, from Penny's.
I really, no, aren't you selling Rustica?
Oh, no, we're opposite Street 46. Pastries,
okay.
yeah.
Very.
But we're equal opportunity, so maybe we'll do some Rustica, too.
It's wonderful. Yeah. We'll close the public hearing and let Councilmember Fry. Oh, you have a question for Mr. Phillips? Okay. Councilmember Fry?
I'm interested in the kinds of beer and wine and what's going to be the vibe.
It's going to be very unusual and expensive beer and wine.
I hope so, yeah.
Yes. Esoteric. We're trying to elevate the experience, and as a result, going to offer unique wines and beers and ciders that are not often found here, and trying to elevate it, and by design, too, to attract the more sophisticated clientele.
Yeah, the space looks incredible.
Thank you.
It's beautiful. It glows in the heart of downtown. I just love the way it looks.
Thank you. Well, we appreciate the opportunity.
Anyone else here to speak to this issue? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. I am thrilled to move approval of this item. It's been, Mr. Phillips, it's been a pleasure working with you and your team through this process, and I'll say this is far more than simply a coffee shop in the area. Yes, they have spectacular crepes there. Yes, they'll have interesting and nouveau beer and wine there, which is also great. But I think perhaps most importantly, it's filling in a major gap that was previously dead space between the action happening in East Town and then the action happening on Hennepin going into North Loop. It was a bit of a void, and now people are walking to go check out Penny's. It's not simply a coffee shop. For those that are in the 100 Washington? In the crossing. Yeah, people from the crossings are heading over there. I think people from City Hall are heading over there. So it's I think a really nice centerpiece for that area right now, and we're proud it's there. So thank you for your investment.
And Councilmember Fry's motion to approve, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We only have one item remaining on our agenda. This is the quasi-judicial public hearing for the license application for Bond Bowls. So I just want to note if anyone is here for any of the consent items, those were taken care of at the very beginning of the meeting. Councilmember Fry chairs the quasi-judicial public hearing, so I'll turn the chair over to him.
Thank you, Madam Chair. We have one item on the quasi-judicial agenda for today, item number 6, which is a restaurant license application for Bond Bowls, LLC, doing business as Bond Bowls. And here to present today is
Mr. Vice Chair.
Go for it.
I'll be representing Joel Fussy from the City Attorney's Office. I'll be representing our Business Licensing Division today with regard to this matter. And essentially it involves a restaurant application by Heidi Pham and Bond to Bowls LLC to operate an establishment proposed to do business as Bond to Bowl. It would be located at 27 South 7th Street downtown. This past fall, the Business Licensing Division notified the applicant that it was recommending denial of her restaurant application, and the applicant, as is her right, appealed that recommendation. And so an evidentiary hearing took place in front of Hearing Officer James Gurovich on October 24th. And subsequent to that hearing, the hearing officer issued the detailed 7-page findings of fact, conclusions of law, and recommendation that is in the council record today. In that order, the hearing officer recommends that the City Council deny the restaurant license application and goes into great detail explaining the factual and legal rationale supporting that recommendation. I would simply request that this committee adopt that recommendation and deny the license application for the reasons contained therein, which include but are not limited to the following. In the few months prior to Ms. Pham submitting her present application for the restaurant, her domestic and business partner and the father of her 4 children, Thomas Pham, had submitted and pursued a substantially identical application for what is in essence the exact same restaurant proposed to operate in the exact same location. However, Mr. Pham withdrew his license application after he was notified of his clear ineligibility for licensure. Mr. Pham was and is ineligible for licensure for 3 reasons. First, the previous license he had to operate another restaurant in Minneapolis had been revoked within the past 5 years by this council. Second, he had recently been convicted of a felony criminal charge for issuance of a worthless check to a restaurant vendor. And third, there were multiple outstanding and delinquent judgments against Mr. Pham or entities that he controlled. Very shortly after the withdrawal of Mr. Pham's license application, Ms. Pham filed an application for what is essentially the very same proposed establishment. Pursuant to Ms. Pham's application, Mr. Pham would still be significantly involved in the operation of the restaurant, as the record indicates that he would be employed at the restaurant and have responsibility for overall vision of the restaurant, its menu development and marketing, as well as staff training and scheduling and inventory and supplies. This close proximity in time between the two applications, the nearly identical nature of the applications, the continued employment of Mr. Pham in a substantial role in the restaurant, and the fact that Mr. Pham subleased or assigned the lease of the business premises to Ms. Pham all indicate an impermissible and continuing and substantial financial and operational involvement of Mr. Pham, who is clearly ineligible for licensure, in the proposed business of Ms. Pham. Additionally, as the hearing officer found, there are past as well as ongoing business relationships that Mr. and Ms. Pham have entered into with previous restaurants in Woodbury and St. Louis Park, which have included loans, guarantor status, shared business debts, obligations, and unsatisfied judgments, as well as an unchallenged finding from the Minnesota Department of Revenue indicating that Ms. Pham had previously acted as a business surrogate for Mr. Pham in attempts to bypass his ineligibility in order to obtain a state sales tax permit. The very close personal relationship between Mr. and Ms. Pham also supports the finding that the two license applications are inextricably and impermissibly intertwined, such that the present application of Ms. Pham represents an attempt to avoid the clear ineligibility of Mr. Pham. Although Mr. and Ms. Pham have not been formally married, they are domestic partners with 4 children, and the record establishes that the proceeds from the proposed licensed business would be used for obligations common to each, including raising their children and jointly contributing to the settlement of shared legal obligations. The findings issued by the hearing officer are extensive and go into much greater detail on the basis I've touched upon supporting denial of the license application. The findings also detail other issues with the application, including the failure of the application to fully and accurately detail the residential and work history of the proposed general manager of the restaurant, James McHaney, for whom a period of incarceration following a felony conviction was not disclosed. In sum, I submit that the record in this matter supports the essential findings and conclusions made by the hearing officer when he recommended that the City Council deny the restaurant application at issue, and I would respectfully request that this committee adopt his recommendation in full. Thank you. I believe that a representative of the applicant may be present.
Thank you, Mr. Fussy. Do we have any questions for staff at this point? Seeing none, I will read a brief introductory statement. This is a quasi-judicial license hearing for which this committee is limited by law to hearing argument from the licensee or the license requester, owner, or the owner's representative, but is prohibited from considering any further evidence or taking any further testimony. This means that you are required to limit your comments or arguments specifically addressing the evidence or testimony introduced before the hearing officer, which is part of the record that is already before us. You may not offer and we may not consider any new or additional evidence based solely on this existing record, and the argument that the parties make today, the City Council may affirm, modify, or reverse the recommendation that is before us. Is either the owner or representative here today?
Yes, Councilmember.
Please begin. Thank you for being here. If you could state your name and an address for the record.
Good afternoon. My name is David Klink, and I'm an attorney with Bridge Law Group in Minneapolis. I'm here representing Heidi Pham and Bondable LLC. Good afternoon, Madam Chair, Councilmember Fry, and council members. Also, Mr. Fussy. Licensing has not evaluated my client's application on its merits. Rather, licensing is treating the application as though it were brought by Tom Pham. Tom and Heidi are not married, and therefore MCO 188-185F doesn't apply here. They have the same last name because it's a common last name. It's a common last name in the United States and in Vietnam. Heidi's mother's last name is Pham. We've never hidden the fact that they have a relationship, but whatever relationship they may have is simply not material to the merits of Heidi's application because the city code requires marriage. Heidi does not enjoy the tax benefits, estate benefits, government benefits, employment benefits, medical benefits, death benefits, family benefits, housing benefits, consumer benefits, or other legal benefits or protections of marriage. Licensing seeks to force Heidi to suffer a drawback of marriage, even though she has no access to its many benefits. This is simply unfair to the applicant. Licensing's arguments are built on innuendo stemming from their disapproval of Tom Pham. This is inappropriate and frankly demeaning to Heidi Pham. Heidi is a successful, licensed business owner in the city, operating a nail salon in downtown Minneapolis in the Macy's Arcade, the same building in which Heidi's license is proposing to operate this sandwich shop. Indeed, licensing's references to the denial of Tom's application are actually inappropriate on their face, given that the application that Tom made was withdrawn, and licensing indicated that if he chose to exercise the option for withdrawal of that application, that it would result in no formal adverse licensing determination. Instead, their entire determination on Heidi's application is riddled with commentary on Tom's application. As my colleague, Mr. Stam Stern's written submissions to the council well illustrate, licensing has started from a conclusion here. They feel that Heidi is just Tom's proxy. Never mind that Heidi is her own person, with her own successful business in the city, that her name is assigned and therefore will be on the lease, Tom's will not, that it will be her name on the business license, and it will be her money and reputation put at risk in running this business. Licensing has started from their conclusion, and then they've sought to build a case against Heidi, throwing everything they can at her and hoping something sticks. This is not how licensing should be operating in this city. The basic facts here are straightforward, as evidenced in the record from the hearing. Tom Pham came up with an exciting concept for a Vietnamese sandwich shop in the Macy's Arcade. He signed a lease, purchased equipment. He had trouble getting the license, as Mr. Fussy outlined. He then chose to withdraw his application and instead sell this great concept and the equipment to another party. Heidi Pham is that other party. She's not trying to hide anything here. She believes in this concept. She knows how to successfully own and run a business. And she's excited to own two businesses in the Macy's Arcade. She has a manager lined up in James McCaney, who's competent to run the day-to-day of the sandwich shop. And the testimony on the record is that Tom Pham's only role will be as a temporary employee of the shop to help create the menu. Mr. Fussy had the opportunity to challenge that testimony by Tom and Heidi and Mr. McCaney at the hearing, and he chose not to do so. The only evidence presented to the hearing officer is that Tom will create the menu. Essentially working as a consultant, he's got his own full-time job at another restaurant. That's the plan. Tom will have no part in the finances or management of the shop. He won't even be regularly there. And by the way, both licensing and revenue have indicated that they have no issue with Tom serving as an employee of a restaurant in the state or the city. Furthermore, revenue has shown that if Tom is involved with the management or finances of a restaurant, they'll shut it down, resulting in hundreds of thousands of damages to the restaurant owner. The sword of Damocles is hanging over Tom Pham's head. Heidi is well aware of this fact, and she has no desire to expose her business interests to this risk. The City Council can rest easy knowing that revenue is approved of the arrangement here, and they have no problem with Heidi running the business. And if licensing's erroneous conclusion ever becomes reality, revenue is watching. Mr. Stern's written submissions do an excellent job of disarming various arguments that licensing has made here. In the interest of brevity, I'll just briefly note on two that Mr. Fussy touched on. Mr. McCaney, the proposed manager, his address history issue is a red herring. It wasn't a grounds for denial of the license. It came up after the fact in the hearing. And there was no fraud in submission of the application. The form asked for 10 years, and we offered 7, but we clearly showed the years that he was living there were only the 7 years. We weren't trying to fraudulently allege that he had lived anywhere for the 3 remaining in the 10. If they wanted to know the 3 remaining, they simply could have asked. They asked a number of questions after we submitted the application, and this didn't come up. That's how they operate. They ask questions, they work together with the applicant to get the application right, or they deny it based on the lack of specific information, and neither thing happened here. Minneapolis, the other thing is that this isn't a material issue. Minneapolis Code specifically has a 5-year look back on criminal records. Mr. McKinney deserves a second chance under our city's law. Had we divulged that he was in prison 8 years ago, it would have constituted a de facto look back at his far distant and irrelevant criminal record. That would be unfairly prejudicial to Mr. McKinney and to my client, and indeed, it now has been. Second, the judgment against Heidi Pham was not related to her business. Heidi Pham had no interest in Tom's Restaurant business. She was never a guarantor of Tom's Restaurant business. She did not sign a guarantee. She had no involvement with it. There's nothing in the transcript to the contrary. She wrote a check for Tom as a personal favor. He was supposed to give her the money the next day into the account. He didn't. It bounced, and she got on the hook on the judgment for that reason. But that was a personal favor. She had no role in the restaurant, and by the way, she has a payment plan worked out with the creditor, which she has been making the payments on. She is paying the judgment. In conclusion, if the City Council chooses to uphold licensing's recommendation here, it sets a dangerous precedent. There's no city code prohibiting licensing in cases of guilt by association, unless it's a spouse. And spouses can break that link by getting a divorce. Heidi can't divorce Tom because they're not married. There's no substantive violation of the city code here. One might argue that following licensing's recommendations would be following the ethical aspirations of the code, but past precedents of this council make it clear that violations must be substantive and not just aspirational. Furthermore, there is no aspirational violation here. Following license recommendation would send a message to female business owners that they are defined by the men who they choose to associate with, even if they don't take the step to marry them. Heidi is exactly the sort of upstanding, successful business owner that this city hopes to attract and retain. I'd be happy to field any questions the council may have, and thank you for your consideration.
Thank you, Mr. Klink. I have a couple of questions. So there's no dispute that Mr. Pham originally attempted to be the licensee on the property prior to Ms. Pham. Is that
technically, I believe it was a company of which Mr. Pham was the sole owner, but there's no dispute as to that. Okay.
Several of the pieces that you mentioned did resonate with me. The one that didn't is the question of, well, this sets a dangerous precedent that is purely against women. Because I feel strongly that if it were the opposite way around, if it were originally Miss Pham that had tried to open the business and then it was transferred over to Mr. Pham, I think we would be asking the exact same questions, especially since it's precisely the same parcel. Does anybody else have any other questions for the applicant? Thank you. I have a couple of questions for staff, though.
Thank you.
Mr. Fussy, can you outline the law for us with respect to the requirement or lack thereof of a spousal or familial relation?
Yes, Mr. Vice Chair and committee members, it is correct that there is a provision in the Minneapolis Code, I believe it's 188.185, which sets a minimum threshold and states that if a license holder has an application revoked, the revoked license holder, the license cannot be issued in the name of the spouse for, I believe, a period of 5 years. My view is that that's a minimum threshold, and we're not basing this action upon that ordinance. Rather, we're basing it upon the good cause clause in the charter and the other ordinance sections that are cited within the findings of the hearing officer. Furthermore, I think that relevant case law establishes that it certainly does establish the fact that just because there is a familial relationship or a personal relationship between one person and another, that the, for lack of a better term, sins of the other cannot be cast upon the new applicant. That is true, but that's in the absence of any actual business or operational connection. In this case, there is extensive operational and business connection in terms of the proceeds, in terms of the fact that to whatever extent it is, Mr. Pham will be an employee of this restaurant and will have the overall vision of the restaurant as it was established in the record. And furthermore, as I think the record establishes, and what I think is very important is that the Minneapolis or the Minnesota, the State Department of Commerce revoked a sales tax permit held by a corporation that ran the restaurant in Woodbury that was purportedly wholly owned by Heidi Pham. And the MDOR cancellation was based upon a determination that Tom Pham, who is ineligible to obtain any new sales tax permits based on his previous failures to comply with sales and use tax laws and rules, maintained a financial and operational role in the Woodbury restaurant that was supposedly in the name of Heidi Pham, exactly the same scenario that's proposed to operate here. In that Woodbury restaurant, as in the proposed restaurant that is the subject of this proceeding, Mr. Pham appeared to be a primary or at least significant operator of the business, despite the utilization of corporate veils to minimize his involvements. That's exactly the case that we have here. And in that, with that restaurant in Woodbury, when the state revoked its sales tax permit, Heidi had an opportunity to challenge that, and she chose not to. And so I think that's a striking parallel and establishes a precedence that there is a history of this kind of operational collusion between the two parties. And so although I certainly concede that just the fact of a family relationship or a personal relationship is not in and of itself enough to trigger license denial, except for the case of where it is a spouse, I believe the law definitely allows and recognizes that it can still be a basis for a denial if there are other factors, and there are abundant factors in this case.
Mr. Fussy, this matter in Woodbury was litigated at least administratively?
Mr. Chair, could you repeat the question?
The matter in Woodbury that you had just mentioned, it was litigated at least administratively, so it is on record? I mean, it's...
I believe that's correct in that the MDOR cancellation was sent in a notice to the Woodbury restaurant that was in Heidi Pham's name, and as part of that administrative determination, they had a right to appeal that or to challenge that, and they chose not to. So it's a vested determination that occurred. There was an opportunity, there was due process provided to challenge that finding, and it went unchallenged. And so I think that it's entirely proper for the city to, and as the hearing officer in this case did, rely on that determination by the State Department.
Councilmember, may I please request a brief rebuttal?
Yes.
Thank you. On the issue of the law, the only code section that's relevant in the administrative hearing officer's opinion to the relationship between those two parties is 188.185F, which specifically reads, no license shall be issued or transferred to any person who has had a license revoked within 5 years prior to the date of the application under the terms of this chapter or the statutes of the state of Minnesota, nor shall any license be issued or transferred to the spouse of such a person. End quote. That's the whole provision. There is no other provision under the city code relevant to the relationship between those two parties. And Heidi, as I've talked at length, is not a spouse. As to the case law that Mr. Fussy discussed, they cited one case, Wajda versus Minneapolis, in which the city council's denial of a license to the mother of a former license holder was overturned by the court as being arbitrary and capricious. Yes, there is a bit of dicta in that opinion discussing other relationships, but it's in the legal world.
What does the dicta say?
I don't have the case in front of me, but I believe it discussed how, do you have it, Mr. Fussy? I believe it discussed how you could possibly consider other relationships beyond the spouse, but they didn't there. There is no case presented.
Mr. Fussy?
Mr. Vice Chair and committee members, I don't have this specific language, but counsel is correct that the court holding was that in the Wajda case, there was no operational connection between the mother and the son. And it recognized that in that narrow circumstance, that could be arbitrary and capricious. It would be the city's position. Obviously, the applicant would disagree that when there is such operational connections, and in this case, substantial, ongoing, and continuing, I think it's perfectly proper to and incumbent upon the licensing agency to not allow basically what would be a sham.
So the argument, Mr. Fussy, is that it doesn't hinge on the familial relationship. It depends on the operational relationship, which is ongoing.
That is my position, yes.
In the second half of the rebuttal, so as to that, they're asking for an extension of law that's not written into the law. But as to the second half, the Woodbury issue, revenue has specifically stated that what we are trying to do here is permissible. It was a completely different situation in Woodbury where Tom Pham had check writing authority and management authority of the business. He was the manager of the business. He was writing checks for the business. The Heidi's application here very specifically does not allow Tom to do any of that. He's going to consult on the menu. That's it. In order, Mr. Fussy's argument rests on the assumption that we're trying to do the exact same thing we did before that cost us $200,000 and an awful lot of legal bills and pain. We've learned from Woodbury, and we're trying to do something that is permissible and that revenue doesn't have a problem with. If Heidi can't do this, she can't do anything in this city. And she has no way to fix it by divorcing Tom because she can't divorce Tom because they're not married. Thank you.
Thank you, Mr. Klink. Councilmember Goodman.
Thank you, Mr. Chair. I am going to move the staff recommendation. I have not been convinced one bit by the applicant's attorney. In fact, I will just note that the hearing officer was pretty clear that the evidence of impermissible and continuing and substantial financial and operational involvement of Mr. Pham in the proposed establishment is unbelievable. Basically, he said there was tons of evidence, and the findings of fact list from the hearing officer, plenty of evidence to suggest there were problems. I think the thing that's interesting is that you don't mention all of the failed businesses and all of the people who have lost money as a result of the failed businesses by Mr. Pham in various locations of him and his wife, who are basically de facto married. Please sit down. You don't get to speak anymore. So it just seems to me as though what you're suggesting, that they're not at all connected. There's no financial connection. There's no operational connection. They're not connected at all. But they came in. I mean, the evidence suggests that Mr. Pham came in and tried to get a license, and when he heard he couldn't, he immediately turned around and said, well, then my partner will. It's in the findings of fact. I mean, he said it in front of a bunch of people. So unless this arbitrator's process is fake, and I don't believe it is, I believe we have extremely strong standing here legally to move forward. And I'll tell you, we get hundreds of requests for business licenses in the city in the year, and the number that we don't grant, I probably could count on two hands. Wouldn't you say that's true? We want people to get licenses in the city. We want to see businesses operate. We want to see small, minority, women-owned businesses operate. We give them money. We help them with financing. We go out of our way to locate them. So I'm offended that you would suggest that this is discrimination against women. If that's the best you can come up with in this situation, after the number of things that have happened with regard to failed businesses and inability to pay taxes, it's astonishing to me that you even had us hear this, given what's happened so far. Wait your 5 years, come back and apply again when the 5 years is done, and we'll happily do business with them once they've paid their debt, not the debts, but their debt to the city for having all of these problems in the past. I think this is a no-brainer as far as I'm concerned, and I think it's really sad because Mr. Pham has operated some great restaurants in our city, but I think they've all kind of ended the same way, like the ones did in Woodbury, like the one did in St. Louis Park.
There's a motion from Councilmember Goodman on the table here. Are there any further comments on this item? Seeing none, all those in approval, please say aye. Aye. Chair Goodman.
Thank you, Mr. Vice Chair. There are no additional items in front of us that need any attention, so this committee's business is completed and we are adjourned.